Sorry I'm at your back, but please go ahead and get started.
Good morning. My name is Tina Manassian, and I was the victim of a doctor who participated in the former diversion program run by the Medical Board of California. I wasn't his only victim. There are countless others that have suffered and have passed away. In 2002, he performed a surgery on me that I was not a candidate for. 12 years later, I still suffer from the lingering effects of the surgery with excruciating pain and spitting sutures. During that time, he was at his all-time high with his alcohol problem, and the medical board was trying to revoke his license, but I didn't know any of this. He was in a secret and dangerous program called diversion. The issue was he failed diversion twice, but they allowed him to continue to practice medicine. Some of the folks here were on that same committee with diversion. The diversion program was a monitoring program. When the medical board becomes aware of a substance abuse problem in a physician, they divert the physician into a program as opposed to taking away his license. The idea being getting them into recovery, rehab, and put them back into practice when it's safe to practice. And during that time period, they're supposed to monitor him, do random drug testing, attend group meetings, and have ward-side monitors when they're permitted to return back to practice. They used a lot of monitoring mechanisms in the program in an attempt to monitor the physician's behavior. The problem is none of those monitoring mechanisms were effective at all. They were inadequate. The random drug testings were not random at all. It was done on many times on days the physician can anticipate and manipulate. In my case, my doctor was allowed to have his own office manager, an employee of his, a person he can hire and fire, be his worksite monitor. She lied for him on AA records, stating that he attended meetings when in fact he never went. And they tried to dilute his urine when he was being drug tested. The medical board's diversion program was a failed 25-year program. It was audited 5 times, and they failed all 5 audits. The problem I have with this bill, AB 32346, it creates another diversion. They may not say it's a diversion. It smells like a diversion. It is a diversion. It's a diversion program, except this one not only keeps doctors' substance abuse problems secret from patients and the public, it also keeps it secret from the medical board. Now, Granite Construction just talked with one of the construction supervisors this morning. They are drug tested every single week. Doctors should be held to a higher standard. I strongly urge you to oppose this bill. It does not protect patients, and patient safety is at risk.
Next witness, go ahead.
Mr. Chairman, members, Ed Howard, Senior Counsel for the Center for Public Interest Law at the University of San Diego. Thank you for your time and the attention of the committee. We rise in opposition to this bill for 3 reasons. The first is that there are no restrictions on the discretion of the medical board and what it may authorize, except for 2 things. The first is that doctors must be protected by ensuring that their participation is absolutely confidential. There is nothing in this bill that says confidentiality does not extend to the medical board, meaning this bill, as it currently reads, and as you will be voting on it today, authorizes the medical board, which last time it was involved failed 5 audits, and whose major charge is to protect patients, not physicians, but you and me and our loved ones and our constituents. That's their charge. This bill authorizes the medical board to create a program that would allow doctors who are currently drug or alcohol addicted to continue to practice without the patient knowing, without the medical board knowing, without the hospital knowing, without anybody knowing. That is permitted by this bill. Likewise, the only other benchmark in the bill as to what it's going to do is that it should be modeled after the lawyer's assistance program. Now, as a threshold matter, the risks involved in providing legal services versus medical services cannot respectfully be compared. I am a lawyer. I will be doing law all day. There is no risk today from what I do that anyone will die. But that is not true every single day with the vast majority of people who are licensed as physicians. Every single day, they are doing things which could kill us or our loved ones. And to boot, I am not, as a lawyer, surrounded all day by among the most addictive narcotics known to man. Doctors are. So as a threshold matter, the idea that we can compare the lawyer's lap program with any kind of program which would monitor drug and alcoholic doctors who deliver our babies and perform our surgeries is respectfully just an inapt analogy. But worse, the last time anybody objectively looked at the lap program, it failed. In 2011, the Bureau of State Audits looked at the LAP program, and it found that only 11% of the participants completed. Quote, it had poor monitoring procedures. Quote, it failed to send reports about lawyers who had flunked drug tests to the bar. It had failed to send reports about missed lab tests. And it failed, in several instances, to send reports on time. One as late as 52 days. And one participant documented in the BSA audit failed the drug test 20 times before the case manager actually reported it. So in sum, the LAP program, the last time anybody objectively looked at it, the last time that you, this committee, has any objective information about its performance, it flunked. And the LAP program in the text of this bill is the inspiration for how your patient, how your constituents will be dealt with by drug and alcohol-addicted doctors. One final note. Thank you, Larry. One final note. I appreciate your indulgence, Mr. Chairman. I've been up here since 2001. There are many, many topics that are appropriate for last-minute bills. Bills that are gutted and amended several days before a hearing. Respectfully, not this one. Not this one. All of you up here make enormous sacrifices to do the work that you do in the public interest. There are very few things as bedrock important than the life and death of your constituents when it comes to drug and alcohol addicted doctors. Every other bill that has failed so far, every other bill has contained bedrock consumer and patient protections that are entirely absent from this bill. The two Fuentes bills that were vetoed by the governor were guaranteed, not diversion programs, guaranteed notice to the medical board when people flunked, adherence to the uniform standards, making sure that the very same people who destroyed the diversion program can't run this program. None of that is in this bill. None of the protections are in this bill, and they were in the other ones. This is not appropriate to rush through, respectfully, and I respectfully urge your no vote. Thank you.
Thank you. Other witnesses in opposition, name and organization, please.
Mr. Chair, Christopher Dolan on behalf of the Consumer Attorneys of California. I'm here today to talk about the issues that are previously that the medical board has tried to do. Many of mine have been spoken about by my colleague, but I brought a summary that I'd like to have provided to the committee members, which was, Sergeant, which was put together by the leader of the last audit, and there are state audits also available that detail the medical professional's ability to police itself. And I'll just talk about two small points. One, the doctors were supposed to be randomly tested. Instead, they were tested on Tuesdays through Thursdays, and they knew when to expect the tests so that they could party over the weekend. That was found to occur within this report. The other item was that out of 32 participants who were found to have dirty drug tests, 12 of them were still allowed to be practicing medicine. So while you have a very vague indication that there is some program that will be created that may be like the lawyer's program, it lacks the very specifics that are needed to protect people. Otherwise, it's just a smokescreen. So I urge you to please read this very brief summary. We can provide you with the dollars spent on the audits by the state and the audits themselves, but I urge a no vote. If diversion is truly the goal, then it should be done in a complete and thorough and responsible manner. Thank you.
Thank you. Other witnesses in opposition? Okay, we're bringing back up neutrals.
Morgan Carvajal on behalf of the Consumer Watchdog, also opposed.
Thank you.
For the records, Consumers Union also submitted a letter in opposition.
Thank you. Thank you. I think questions from the dais, from the members? Mr. T.
So I'm, obviously very supportive of the program for wanting physicians to get treatment. I am concerned about the number of issues that were raised by the opposition. Can you talk about one, the consumer protection issue, but also I was going to ask the opposition. I was also going to address the opposition, but I was curious what the opposition would propose, because clearly, if they're against this program, what would they propose in terms of, obviously we need physicians to get some treatment, and I understand your concern about confidentiality, but if it wasn't confidential, what incentive would a physician have to come forward? So I guess two separate questions.
Well, first, and I think and understand the concerns of the opposition, but I feel like they're opposing a bill that I didn't present. Quite frankly, this bill doesn't allow for diversion. This is a voluntary program where people hopefully would prevent themselves from being in a situation where they had the need for diversion of any sort. It specifically says that, again, this isn't under the medical board. It allows them to contract with a third party. We chose to create a program. We had hoped originally to put it directly into the lawyer assistance program because there's just no legal way to do that. But we want the program modeled after a program that, while the opposition says had a bad audit in February of 2013, the BSA followed up and said that all the recommendations had been implemented from their audit where they found failures. So we have a program that I think works well for the legal profession. I mean, perhaps that needs to be looked at as well, but most, in fact, the audit came back to say it's now strengthened program, and one which we want to encourage doctors who, by their own volition, know that they need help. It is a preventative measure. There is nothing in place now. I'm not fighting about drug testing. I'm not having a discussion about diversion. That's not what this bill does. This bill simply creates a program, a new program. We're not relitigating whether the past program worked or it did not. Obviously, it did not. But this is a new program that doctors, prior to any kind of disciplinary action, we don't want this to supplant disciplinary action. This is on their own regard. If this is a profession that is so riddled and so in need of assistance because of drug and alcohol abuse, then how do we not have a program to try to prevent this where doctors can themselves put them into this regard?
So, Assemblymember, thank you for your question, and I thank the Assemblymember for her comments as well. As a threshold matter, as a matter of administrative law, what is not forbidden is allowed. All of the other bills that we have worked on collaboratively with CMA to try and address this issue have asked for four things, Assemblymember, and we would not be opposed. The first is that there is a guarantee somewhere in the bill that this is not a diversion program. To explain what that means, by the way, it means that previously drug and alcohol addicted physicians were diverted, who came to the attention of the medical board's disciplinary arm because of complaints. Those folk were diverted, hence the name, from a disciplinary track into the secret monitoring program. And it's that monitoring program. It's not a treatment program. That monitoring program is the one that failed 5 audits. So the four things are, first, something in the bill that says that it's not diversion.